Now we are moving on the second chapter, which is related again with the formation of contract. What is this formation of contract? Which of the following is executed consideration? Consideration means payment. I am going to pay a certain amount if someone performs a certain job for me. Providing goods in return for payment at the same time. This is called consideration, or a promise of payment in return for a provision of goods at a later date. A promise to pay for work already carried out. Here he is not asking only for the consideration, he is saying executed consideration. What does it mean, executed consideration? Executed consideration is the one which takes place at the same time. Executory consideration takes place at future date. Executed, it happened now. Executory, it will happen in future. Past consideration is something which has already been done. So here he is asking about executed. So this one is the right answer, which is called executed consideration. Next one is, which of the following describes how courts deal with advocacy of consideration? Court will seek to ensure that consideration from each party is of equal value. Consideration of consideration from each party is of equal value. Number two, courts will seek to ensure no party makes excess profit, means it is not the win-lose situation. Court will not interfere in any contract to rectify a bad bargain. Definitely, courts are not expected to do this. Courts will not interfere in contracts in regard to the adjudicacy of consideration. Both the parties has decided a consideration. Now they are liable to follow their contract. Court cannot intervene and can't say that you are paying lesser amount of consideration and you should pay more. Then, which of the following statement regarding advocacy the and sufficiency of consideration is correct? Consideration does not need to have a value to be sufficient. This is not correct. Consideration is sufficient if it has some economic value. Definitely, economic value is needed. Nowadays, we are not using barter system. We are using cash system. Consideration does not need to be sufficient and must be adequate, but must be adequate. Consideration must be sufficient, but not necessarily adequate. It must have some economic value to sufficient, right? Next one is, which of the following is true regarding of privity of contract? Okay. Third parties to a contract generally have enforceable rights under it. Number two, only parties to a contract generally have enforceable right under it. Number three is, privity of contract only relates to rights under a contract, not obligations. First one he says, third parties to a contract generally have enforceable rights under it. It is not relevant with the privity. Privity means what? Privity means what? Only parties to a contract have enforceable rights under it. Only the relevant parties, not the third party. In fact, the concept applies to both rights and obligations under a contract. Generally, third party do not have enforceable right under the contract, and privity of contract is the one where all the relevant party have enforceable contract. So that's why only relevant parties is the right answer. Next one is, which of the following is not an exception to the rule of privacy, not an exception to the rule of privacy of contract. Okay. Okay. The next one is, which of the following statements regarding intention to create legal relations is correct? Intention to create legal relations. Social arrangements are generally intended to be legal binding. Social arrangements are not the legal binding. These are the social arrangements, general arrangements. These have nothing to do with the legal bindings. Commercial arrangements are generally not intended to be legal bindings. Again, why not? A contract between a contract will be legally binded if both the parties are intended to do so. Yes, this is the definition. And B, second, this one is incorrect. Are generally not intended to be legally binding. Presumption is that social arrangements are not intended to be legally binding. Hey, these are not intended. Commercial arrangements are intended to the legally binding, and a contract will be legal binding if both the parties are intended to do so. Next one is, which of the following indicates that parties intend to be legally bound? Parties intend to be legally bound. A letter of comfort, an agreement between a husband and a wife to transfer property between them, an agreement binding in honor only. Legally bound means an agreement where husband and wife to transfer property between them. The courts are very ready to impute an intention to be legally bound where a husband and wife agrees to transfer property between them. Letter of comfort and transaction binding in honor only both indicate there is no intention to be legally bound. Which one of the following is a correct rule for valid consideration? Correct rule for valid consideration. Consideration must pass from the promise. Consideration must be adequate. Past consideration is generally valid consideration. Executory consideration is generally not valid. Here is saying valid consideration. Consideration must pass from the promisee is called what? Valid consideration. It must be sufficient, not necessarily adequate. Past consideration is generally not valid consideration. Executory is generally valid consideration. So here use of not is incorrect. Here there is no use of not. So here we have consideration must be sufficient but no, must not be adequate. So that is why B3, second, third, and fourth are incorrect. Which of the following statement is true of consideration? Past consideration is sufficient to create liability on a bills of exchange. I hope you know what is bills of exchange. Suffering some loss or detrimental is not valid consideration. Is saying true of consideration. Consideration can be in the form of any act, even if that act is impossible to perform. How? Performance of an illegal act is valid consideration. Okay, the first one is past consideration is sufficient to create liability on bills of exchange. This is the right answer. This is one of the few exceptions to the rule on past consideration. Suffering loss or detriment is valid consideration. Impossible or illegal acts are not valid considerations. Next one is where a party accepts part payment for a debt. They may at a later date request payment of the amount outstanding unless the other party provided extra consideration when making the part payment. He says where a party accepts part payment for a debt that may at a later date request payment of the amount outstanding unless the other party provided extra consideration when making the part payment. Which of the following are valid consideration for part payment of a debt? Payment in the form of goods rather than cash, payment by a third party rather than debtor, and intention by the debtor to be legally bound by the uh, part payment, guarantee by the debtor to make the payment on the date agreed in the contract. Here is he saying valid extra consideration for part payment of a debt. So this one payment in the form of goods rather than cash and payment by a third party rather than debtor. Extra consideration to be valid, creditor must become entitled to something that they are not already entitled to. In fact, goods rather than cash and payment by a third party are valid examples. A guarantee of payment and payment on time are not valid as extra consideration because the creditor is already entitled to them. Next one is which of the following six statements regarding consideration is correct? Performance of an existing legal obligation is valid consideration for the promise of additional reward. Performance of existing contractual duty is sufficient consideration for the promise of additional reward. Performance of an existing contractual duty to a third party is sufficient consideration to the promise of additional reward. Performance of an extra service in addition to an existing contractual duty is not sufficient consideration for the promise of additional reward. Okay. Performance of an existing legal obligation is a valid consideration for the promise of additional reward. Next one is performance of an existing contractual duty is sufficient consideration for the promise of additional reward. Okay. Now, which of the following statements concerning privity of contract is correct? Privity of contract means only parties to a contract may sue on it because it is between the two parties or relevant parties, either two or more. Privity of contract means that only parties to a contract may sue on it. The Contract Right of Third Parties Act 1999 is the source of regulation. There are exceptions of rule of privity. Privity of contract applies to all contracts, not just commercial ones. So that is why B, C, and D are the incorrect options. The Contract Rights of Third Party Act 99 sets out the circumstances where a third party has the right to enforce a right that may have under a contract. Which of the following statements concerning the contract rights of third parties Act 1999 is a correct? The third party needs not to be in existence when the contract was formed. So B is the right answer. The third party may not be expressively identified in the contract, may need be expressively. The Act confers right to third parties under a company's constitution. The Act confers right to third parties under the employment contract. Basically, third party need not have been in existence when the contract was formed, but must be expressly identified in the contract. The Act does not confer right to third parties in respect of a company's constitution or employment contract. Next one is, which of the following is true regarding presumption of intention to create legal relation? Parties in social, domestic, and family agreement never intend to a legally bound. Parties in commercial agreement never intend to be a legally bound. The presumption in all agreements is that the parties intend to be legally bound. Any presumption in regard to intention of parties to be legally bound may be refuted, and the burden of the proof is on the party seeking to escape liability. So here he says presumption of intention to create legal relations. Any presumption in regard to the intention of parties to be legally bound may be refuted, and the burden of the proof is on the party seeking to escape liability. Parties in social, domestic, and family agreement are presumed not to intend be legally bound, right? So A and B are incorrect, but this presumption is rebuttable. Parties in commercial contracts are presumed to be intended to be legally bound, but this presumption is rebuttable. With regard to rebutting either presumption, burden of proof is on the party seeking to escape liability. So, any presumption in regard to intention of the parties to be legally bound may be refuted, and the burden of proof on the third party seeking to escape liability is called what? Presumption of intention to create legal relation. Next one is, which two of the following social, domestic, and family contracts would be presumed by the court as intended to be legally binding? An agreement between an agreement where a father offers to pay his daughter a monthly allowance if she continues her education. An agreement between friends to enter a newspaper competition together and share any prizes between them. An agreement between a husband and a wife who have separated for one to rent the family home from the other. An agreement by a son to pay his mother housekeeping money while she stays at home. Two of the following social, domestic, and family contract would be presumed by court as legally binding. This one, where an agreement between friends to enter a newspaper competition together and share any prize between them, and this one, where husband and wife who have separated for one to rent the family home from the other. An agreement from a husband and wife who have separated and between friends who have entered a competition have both held by the court as legally binding agreement. Payment of monthly allowance and housekeeping money are not used as intended to be legally binding. So these were the MCQs of the chapter number 4.